5 second. Start. Feeling aggrieved and dissatisfied with the impugned judgment and order dated 10th June 2021 and 8th November 2021 passed by the High Court of Karnataka at the Harvard bench in criminal petition numbers 101007 of 2021 and 101621 of 2021 respectively, by which the High Court has allowed the said criminal petitions preferred by the accused Subramania and Rajesh, respondent number 1 in the respective appeals, and has directed to release the accused Subramania and Rajesh on bail in connection with case crime number 157 of 2019 of Dharwad Rural Police Station for the offences punishable under sections 120B, 302, 201 read with section 34 of the Indian Penal Code and section 27(3) of the Arms Act 1959. The original complainant has preferred the present appeals. Learned counsel appearing on behalf of the appellant complainant has vehemently submitted that while directing the accused respondent number 1 in the respective appeals to be released on bail, the High Court has not at all considered the gravity of the offences. It is submitted that the High Court has not at all considered the fact that in the present case that there are two eyewitnesses and respondent number 1 accused has been identified. It is submitted by learned counsel appearing on behalf of the appellant that in case of co-accused, namely Umesh Nagappa, URF Sangappa, this court with a judgment and order dated 6th January 2022 in criminal appeal number 39 of 2022 has set aside the similar order passed by the High Court releasing the said co-accused on bail and has consequently cancelled the bail order. Learned counsel appearing on behalf of the state has supported the appellant. We have heard learned counsel appearing on behalf of the appellant as well as the state. Though served, none has appeared on behalf of the accused respondent number 1 in the respective appeals. We have perused the impugned judgment and order passed by the High Court releasing the accused on bail. Even liberty is reserved to the state to move for cancellation of bail in the event of this court cancelling the bail of accused number 4 Umesh Nagappa, URF Sangappa. At the outset, it is required to be noted that in the case of co-accused, namely Umesh Nagappa, URF Sangappa, who was also released on bail by the High Court, this court with a judgment and order in criminal appeal number 39 of 2022 has set aside the order passed by the High Court and has consequently cancelled the bail order in favor of the co-accused. The grounds on which the said co-accused was released on bail and the grounds on which the present respondent number 1 Subramania is released on bail are same. In paragraph 7, the High Court has observed as under. In view of the above and for the reasons stated in judgment and order dated 6th January 2022, passed in Criminal Appeal number 39 of 2022, the impugned judgment and order passed by the High Court releasing the accused Subramanya and Rajesh, respondent number 1, herein in the respective appeals on bail also deserve to be quashed and set aside. At this stage, it is required to be noted that while releasing the accused Rajesh on bail, the High Court in the impugned judgment and order has observed that in case this court cancels the bail granted in favor of accused number 1 Umesh Nagappa URF Sangappa, it would be open for the state to move an appropriate application for cancellation of the bail. Therefore, once the bail in favor of Umesh Nagappa URF Sangappa has been cancelled by this court, the bail in the present case also requires to be cancelled. In view of the above and for the reasons stated above, the present appeals succeed. The impugned judgments and orders passed by the High Court releasing the accused Subramania and Rajesh, respondent number 1, in the respective appeals on bail in connection with case crime number 157 of 2019 of Dharwad Rural Police Station for the offences punishable under sections 120B, 302, 201, read with section 34 of the Indian Penal Code and section 27(3) of the Arms Act 1959 are hereby quashed and set aside. Accused Subramanya and Rajesh are now directed to surrender before the competent authority slash appropriate jail authority within a period of 2 weeks from today. If the accused Subramanya and Rajesh do not surrender within a period of 2 weeks from today, the concerned police authority is directed to arrest the accused Subramanya and Rajesh and the learned trial court to issue non-bailable warrant against them. However, it is observed that the learned trial court to decide and dispose of the trial in accordance with law and on its own merits on the basis of the evidence laid before it and without in any way influenced by any of the observations made by the High Court in the impugned judgment and order which otherwise are set aside by the present order. With this, the present appeals are allowed. Stop.